So a couple of weeks ago, I did a video post challenging retail funds with respect to their current estate planning offerings in their superannuation funds with respect to their death benefit planning. I've had a lot of response to that, and so in this episode today, I'll be going through a couple of those retail funds and what their offering is to their members on death, and just having a bit more of an explore of this issue. So, Challenger, they don't even put their super deed online. Their product disclosure statement is silent on it, as is their binding death benefit nomination forms, but it appears that if no binding death benefit nomination is done, the Challenger deed ensures that those death benefits are paid to a member's estate. Colonial is the same. There's no discretion for the trustee. If there's not a binding death benefit nomination, it must be paid to the estate. One Path, exactly the same, required to be paid to the estate. AMP, if you don't do a binding death benefit nomination, then those member benefits get paid to the estate, but there is an out. If you do a non-binding nomination with AMP, then the trustee has some discretion. And so if you die, your loved ones can influence what that best outcome can be for the payment of those death benefits. Net Wealth has got the same provisions in their deed, but practically speaking, Net Wealth doesn't offer a non-binding death benefit nomination and refuses to provide same. It's too hard for them, they say. Now for the good news, MLC, if you don't do a binding death benefit nomination, it's up to the trustee's discretion. So your loved ones can influence a trustee to, for example, pay those death benefits as part as a child pension with those really good tax outcomes, part as a spouse pension, and part to the estate and as a lump sum, and perhaps going to some testamentary trusts. ING Living used to have no discretion, but they saw the light, and in 2017 they changed their trust deed. So now if a member dies without a binding death benefit nomination, it's up to that trustee's discretion. And so why am I concerned about this? Is one, I don't think a lot of these retail funds are being very transparent that this is what happens if you don't have a binding death benefit nomination. Two, there's some really bad outcomes. Like paying it to the estate is often it can be quite a bad result from a tax perspective, and the estate can be bad, and it's not really looking after those infant kids, or it doesn't always have those best outcomes, and there's just no discretion to fix that up and give the best result for those loved ones that are left behind. And we're talking often these funds are the same funds that have got $1 million of life insurance, have been getting commissions and been getting fees from these members the whole time. When you're talking $1 million life insurance benefit, there's some serious planning and benefits that can happen. But most members, let's face it, they're not going to have an advisor that goes through this, uses a software program like the Allocator or something of the sort, which will figure out the exact percentages where ideally those death benefits would be paid if you died today. So it's better that happens on death, and they can lobby the trustee in those circumstances. But my real ultimate concern is I'm not sure that these superannuation funds, I think they've got these provisions not for the member's best interest, but to keep the trustee and the trustee's employees out of AFCA, out of any kind of complaint process with respect to the exercise of the trustee's discretion. So rather than having some estate planning process where the trustee can be involved to make sure those death benefits get paid in the most optimum way between the loved ones, who have lost a loved one. It's just a really blunt tool where it all goes to the estate. And so look, I'd ask anyone who's advising in this space and advisors recommending clients into superannuation funds is, you're under a duty to act in the best interest of the client. If you're recommending clients into these funds, which really hardwire those death benefits being paid to the estate, and you're not doing an annual review considering child pensions and spouse pensions and a lump sum to estate and testamentary trusts, are you recommending the client to a super fund that's in the best interest of that client? And that's part of your duty. So I'm asking you, perhaps have a think about that. And if it's not, either lobby these funds, or, perhaps you should start thinking about funds that do offer some better estate planning outcomes. Be interested to continue the conversation.